Menendez. The defendants are in court with counsel. All parties are present, both the prosecution and all defense counsel. Morning.
Morning, Your Honor.
We're ready to resume with hearings in this matter. Many issues have been the subject of briefing by counsel, and also the court received another fax last night from the defense. Has that matter been resolved, or is it still subject to some dispute?
It hasn't been resolved, Your Honor. It's never been presented before.
Okay, this is a fax that I received from Ms. Abramson. I assume the prosecution received it as well.
That's correct, Your Honor.
And it relates to supporting documentation submitted by the prosecution in support of their offer of evidence in this matter for hearing today. And the defense says it has not received that. What is the prosecution's position?
Your Honor, first of all, I want to clarify something for the record. These documents that were presented to the court are not in support of any of the defendant's positions. It's not, they're neutral. The problem is that on May 20th, 1994, the court issued an order. Number 3 of that order was, and I quote, when any party requests that the court consider a matter that has previously been the subject of rulings by the court, that party is directed to provide the court with citations to the trial record of the hearing related to the ruling, and to provide the court with a copy of the pertinent pages of the trial transcript that contain the court's previous ruling. Now, that order was sent to us on or around May 20th, 1994. When it refers to any matter that has been the subject of rulings by the court, the people's contention was that most of what we are discussing has not been ruled by the court, but was the subject of other rulings by the court. So we pulled everything that we could find that even tangentially related to any piece of evidence. Now, last week, around Wednesday or Thursday, June 22nd or 23rd, we informed the defense that we had, in compliance with what the court ordered us to do, listed the citations and made the copies. We asked them if they wanted to pick up a copy of these citations. We at no time ever intended to Xerox all of these citations for them and present it to them. These are all from volumes from arguments that they not only participated in, but have all of the transcripts too. Now, they basically told us that they weren't interested in this unless it was served on us. Well, Your Honor, this was not a document, a motion that we felt needed to be served on anybody. They knew what the order was, and as a courtesy to them, we were going to provide them with this. And their response was, we don't want it unless you serve it. Yesterday, they changed their position and asked us if we would fax it to them, or excuse me, the last day we were in court. We agreed, and we faxed it to them. Now, come today, Ms. Abramson sends in a letter that we feel disadvantaged in arguing the pending motion in our court, and she stated that we were not notified by the prosecution that they had filed with the court the actual transcript. And that appears to be what her bone of contention is. Your Honor, citing back to the ruling that I assume this court sent to her the same way they sent to us, it specifically says there in plain English, we want the citations, and you also requested that we provide you with copies of the ruling. So we did that. I don't know how she could not have been on notice when it's written there in plain English, and I assume she got a copy of it since I don't think the court would just send a copy to us. Now she tells us that, or actually all counsel for the defense, I think, are joining in this, tell us that they feel disadvantaged in arguing the pending motion. Your Honor, I find it inconceivable that 4 defense counsel who have reputations for being vigilant and very prepared would come to this court saying we were prepared to argue this on Monday, but we never bothered, even if the court hadn't ordered this, we never bothered to go back and look at the record on all these issues. I find that inconceivable. I believe that this is really just a stalling tactic on the part of the defense. I think we're all ready to go forward, and that's really all we have to say on the subject.
Did the defense wish to respond?
Very briefly, Your Honor. And I remain seated if that's all right with the court.
Yes.
There has unfortunately been a pattern with these particular prosecutors where they refuse to serve documents on us. They tend to have their secretary call our office and demand that we pick up even their motions and pleadings. Now, I don't believe that it's appropriate in legal proceedings that we serve ourselves with their paperwork. What I understood, since I was not called, a secretary called my secretary last Thursday, there was a 4-page citation list that had been filed with the court. And we were to come down and pick it up. And my secretary's response was that my office is available for the service of process between 9 and 5 every working day. And we were more than happy to receive service of this document. There was no mention made that an exhibit, such as the exhibit that we had prepared and filed and served on the prosecution, had been filed with the court. There was no response from the district attorney's office after we indicated that it was their obligation to serve us with anything that had been filed with the court. And when we were in court on Monday, Mr. Khan indicated that he had this 4-page document. How did we wish to proceed? And I pointed out to him that I did not understand why this team of prosecutors did not avail themselves of fax service, because we had always accepted fax service from their predecessors and from every other prosecutor that we're dealing with. And particularly when there are time constraints, so long as they follow the fax service with a mailed hard copy. That was on Monday at about 9:10. This document wasn't faxed to us until 11:19 yesterday. And in reading it, it makes reference to the fact that actual transcripts and exhibits had been filed with the court. And as the court may know, the minute I saw that, when I got back to my office at 2 o'clock, I called the court and spoke to the bailiff and asked the bailiff to inquire of the court whether such an exhibit had been filed. And that was the first I learned that such an exhibit had been filed. I simply think that the ordinary rules, that there's no ex parte communication with the court, that everything that a party files with the court should be served on opposing counsel, should apply to this case.
Let me make a few observations. First of all, it occurred to me in reading the defendant's response to the prosecution's proffer of evidence on behalf of the defendant, Eric Menendez, that the defense had received this information.
Your Honor, they just...
Looking at page 23 of the brief, it refers to the various proffers of evidence.
Oh, that's a different exhibit, Your Honor. The original exhibit attached to the proffer, the original exhibit, we did receive. But the exhibit that contains these citations, we did not receive.
But you received the citations themselves?
We received them yesterday at 11:19 in the morning.
No, okay. You basically, both sides have filed various documents with the court, various motions of one sort or another. The people are offering or trying to offer certain evidence that when they want the court to rule on. The defense has filed opposition to that. And then the court received from one side or the other, I really don't know which side, because I don't think they're labeled this material. I don't know which side submitted what.
We submitted a ring binder with our exhibit.
Well, there are 2 ring binders here, and there are 3 volumes of material such as this. Did you supply this to me?
No,
This was supplied by the prosecution.
That's correct, Your Honor.
Okay, it's unlabeled. There's no way of identifying who supplied it. It's just there. And it was on my desk at one point with a lot of motions filed by both sides.
No, when we filed the ring binder with the court, we made copies of those exhibits for the prosecution. It's their subsequent filing, which is it contains the materials in this 4-page citation list that we were never given.
Okay, you've got their binder, they've got your binder. Is that right?
No.
You never got the binder?
That's not quite
Well,
right. They keep referring
Are you talking to me?
exhibits, Your Honor. We filed a group of exhibits with the court that are clearly labeled exhibits, which counsel received.
In this binder, right?
It's in another binder.
Okay, one of these.
One of those binders
Okay,
has.
one of those is yours and one is a defense.
Right.
Okay.
Now, they're calling something exhibits that aren't exhibits. They are citations to volumes of the transcripts that we all have, that they've been given the citations to, and they have the volumes to. Now, the court specifically.
Okay, that is this material here.
That is, yes.
Okay. And when did you give the defense citations to all those things that you've included in here?
We offered it to them last Thursday, and they physically got it yesterday.
When did you file it with the court?
Last Thursday, when we offered it to the defense sent.
You filed it Thursday and offered the list of those things to the
Right.
defense on Thursday.
That is correct, Your Honor.
And how did you offer it to them?
Our secretary called their secretaries and asked them if they wanted it, and they said no, they wanted it to be served upon them. As a courtesy, we offered it to them because.
How are you
this is
offering
not
it?
an-
How are you offering it to them? What were they supposed to do?
We asked if they wanted to come and pick it up. Miss Towery is one flight up, come down the stairs, and we have somebody out there waiting for her.
And because they didn't accept that, you just didn't put it in a county messenger and send it up to them?
They were supposed to mail this thing, and I thought it was mailed, but I later learned it wasn't mailed.
Who was they who was supposed to
It was
mail
put
it?
in given to the secretary to be mailed, but then she never mailed it because it just got lost in the shuffle. That I apologize for. But the other part, Your Honor, these things are not exhibits, and we never intended to give them copies of what was in that 4-page letter. We were not going to Xerox all that for them. They had that. We were doing it as a courtesy to the court because the court ordered us to do that. But that was not what this issue is, and that these are not exhibits. The court understands that. Ms. Abramson keeps calling them exhibits like something that we filed that the court, that we used to support a position that we had. It isn't. It's something that they were present when it was first argued, and I can't imagine that they did not review this stuff in preparation for this argument today.
Okay. All right. Now I have a better understanding of what it is that you're discussing as far as the documentation. The court did issue an order on May the 20th, and the purpose of that order, and that was just one part of the order, was to require the parties to provide the court with citations to the trial record in this matter of those things that were the subject of prior litigation, and to provide the court with the actual transcript of the proceedings dealing with the rulings on those matters, so that the court would not then have to go back and look through the volumes of transcript to find those things that are much more readily available to counsel. And now I understand that the prosecution complied with that order. I assume the defense has done likewise in providing the court with citations to those matters.
When we filed our response, Your Honor, we accompanied it.
We dealt with each of those items as exhibits and numbered them so the court could follow along with our response. And when we filed the response, we filed a ring binder with all of those exhibits marked and served it on the prosecution.
Okay. All right. It seems to me that in order for us all to have the same information at the same time, there should be some comedy of behavior here, and that each side should provide the other with the same information that you're providing to the court, so that there won't be a later dispute as to whether everything was provided to the court and whether something was left out or something of that nature, that we don't have to have this sort of petty dispute, so that each side, when you provide something to the court, will have to provide it to opposing counsel as well. It is not subject to the requirement of providing duplicates or 2 extra copies, but just the copy to the court along with a copy to defense. I'm only talking now about the attachments such as these that have been provided. There might well be more of such in the future, and if that does occur, then each side will have to provide the other with the same information, so we don't end up with a dispute such as this, which is certainly not a good way of using our court time. As far as whether the defense is ready to proceed with that issue, we'll deal with that in a few moments. I want to lay out an agenda here of how we'll proceed and get some initial reaction from the parties, so that we know where we're going and how this hearing will be conducted.
May I interrupt for a moment, Your Honor?
Yes.
Just to clarify further, so there will be no further disputes, maybe the court needs to define what it means provide to the other side. Does it mean actually serve on the other side, which is what we've always done as lawyers? Or does it
I would think serving on the other side, so that there is proof that you have done what you say you have done, and therefore you don't have to come back in court and make an oral presentation to the court to explain what has happened.
Thank you.
There's clearly a procedure that lawyers know should be followed in serving documents on opposing counsel.
Thank
The principal issue really to be dealt with at this hearing has to do with how the trial will be conducted, whether it will be with one jury or two juries, whether it will be a joint trial or a separate trial. There have been various motions filed by the parties on that subject, and I have to ask for some clarification from each side on that subject. First of all, both defendants have filed documents in support of a joint trial with two juries. Is that the position of both defendants, that you want a joint trial with two juries?
That is our position. Well, let me say that our position is to oppose a single trial with one jury. And therefore, it's our position that the case needs, at a minimum, two juries. But Eric Menendez's position is that, as a matter of preference, he would prefer a separate trial to a trial with two juries, a dual jury trial, such as we had the last time.
And I don't quite understand that preference in light of the pleadings that you filed, that you very strongly argued for two juries.
No, I think it says two juries rather than one jury, but not two juries rather than separate trials. The reason is, although that was our preference the last time around, the fact remains that I believe it will take co-counsel at least 6 months beyond the point when we would be ready to go back to trial for them to be ready. And I simply don't feel it's fair to my client to have to wait those 6 months. It's a matter of speed and not tactics, Your Honor.
All right. And just to inquire, since you brought it up, when is it that you feel that you would be ready for trial?
Well, I've given it a great deal of thought since we were here last, and I've decided that I really should take a vacation since I haven't done that in 3 years, and take a healthy one, a long one. And I have 3 cases to try other cases before I can go. So the bottom line is I think I'd be ready to go to trial the 1st of December.
And you would be in a position to supply the court with a declaration dealing with the trials that you have scheduled as to when they're scheduled and their status and
Yes, I'll
all
be
those
happy to
things that
do
are
that.
required under Section 1050 of the Penal Code.
I'll be happy to do that, Your Honor.
Okay. And then to turn to the prosecution has filed a document in regard to the issue of one jury versus two juries, and very strongly argues for one jury in this matter. Is that the people's position?
That's right, Your Honor.
And is that a conditional position, or is that the position of the prosecution in this matter?
Well, it is conditional. As the court suggested, we may want to submit some issues to the court for rulings to determine whether or not that is feasible. I think that that position will be dependent upon the ruling of the court.
Well, then you don't have a strong position on whether you want one jury or two juries at this point, is what you're saying.
Well, we can't go blindly into a two-jury trial. If the court is going to rule that in a two-jury trial, we get no evidence in. So we simply ask that the court make rulings as it suggested last time that we're going to do, so that we can make that determination.
I didn't suggest I would do that. You raised the subject in response to a similar inquiry that I had of you last time as to what your position is as to one or two juries. And initially you said you wanted one jury, and then when it was further explored, you indicated that you wanted to present some issues to the court for ruling. And I believe counsel for the defense, one or other lawyer for the defense, might have suggested that perhaps you wanted to file something in writing, and then ultimately it was resolved that that's what you would be doing, filing something in writing with a proffer of evidence as to what you proposed. Is it the people's position that each and every item of evidence that you refer to in your document called proffer of evidence is going to be offered by the prosecution in a trial with one jury?
It is our desire at this time to offer that.
Each and every piece of evidence, because in that offer you indicate that some things might be offered, some might not be offered. You
Well,
don't definitively tell me whether you're offering everything there, and so that's my first inquiry.
I can't say that we're definitely going to offer. I can't say that we're definitely going to offer each and every piece of evidence. What I can say is that this is the evidence that at this time we believe there's a strong likelihood that we're going to be presented before a single jury before defendants.
And much of what you indicate in your offer or proffer is evidence that was received by both juries in the first trial.
That is
Is that right?
Yes.
Okay, so assuming that all the evidence that was received by both juries in the first trial are received by one jury in the second trial, assuming we had one jury, is there a people's position as to the rest of the offer of evidence that you make reference to in your document that you intend to offer in that trial with one jury?
Let me make sure I understand the court. Are you saying that if the evidence that is presented before the separate juries individually all comes into evidence?
No, that's not what I said. Assuming all the evidence that went before both juries comes in again, what else is there that you need rulings upon in order for you to make your decision as to whether you are going to ask the court for one or two juries?
Well, I think our key concern in this matter is the admissibility, something that was not addressed by defense counsel, which is the admissibility of the defendant's testimony from the first trial, as well as the admissibility of the December 11th tape without a foundation being laid by Dr. O'Zeal. Those are key issues which were not addressed in the defense motion. I think that is the most important of the pieces of evidence in the prosecution at this time. We submitted other evidence which we would want to introduce before a single jury, consisting of evidence presented before a single jury alone, as well as evidence not previously presented. I think that those are issues which we would have to determine whether or not the evidence is admissible before a single jury conducted with both defendants. But I don't know that it's necessary at this time for us to rule upon, for the court to rule upon every piece of that evidence in order for people to make that determination. I think that the key issue here is the testimony of the defendant from the first trial and the December 11th tape.
Your Honor, the problem with that is it's a circular argument. The defendants at the first trial testified both in front of both juries and separately in front of their own juries. And in so testifying, they dealt with, on either direct or cross, the pieces of evidence that the people are proffering now before one jury that were not cross-admissible in the previous trial. So before we can get to whether the defendant's previous testimony is admissible by the prosecution in their case in chief, on the more general issues of whether that actually is appropriate in any event, whether there's an exception to the hearsay rule that would allow it, or any of those grounds, we still have to deal with what we contend is the non-cross-admissible items of evidence that the defendants refer to in their testimony before we can get to that issue.
Well, the people's offer or document called People's Proffer of Evidence to be presented before a single jury filed on May the 16th. Says at page 13, line 1, the people may also seek to introduce the trial testimony or portions of the trial testimony of Eric and Lyle Menendez. Is it now your position that you definitely intend to offer their trial testimony in the people's case in chief?
Yes.
And you intend to offer all of the testimony or only portions of it?
Our initial position is going to be that portions of the testimony should be admissible.
Well, how would I rule on that without knowing what portions of the testimony you wanted to offer? They each were on the witness stand for about 10 days. What is it of that 20 days of testimony that you intended to offer?
Well, I could outline for the court.
Well, that's what you should do. If it's critical to the prosecution that something be ruled upon before you can firm up your position as to whether you want to ask the court to have one or two juries, then you should do that. I have no way of knowing what it is that you're offering, and obviously no way of ruling upon it until you define what it is that you want. So you should do that. And also you indicate that you want a ruling on the December 11th tape. And you've made some offer as to how you feel you would authenticate the tape and therefore have it received as an exhibit. I don't recall specifically if the defense responded to that particular offer in their response.
We didn't think that, Your Honor. We didn't think that. I thought what we were coming back to do, Your Honor, was to allow the court to make some rulings that would determine whether we're going to have one jury.
That's what we're trying to do.
1211 tape was played before both juries. So as a cross-admissibility issue, there is no issue with 1211 tape. And whether or not people can use it without calling Dr. O'Zeal is going to be a problem, a 402 problem, and maybe a privilege problem, irrespective of whether there's one jury or two juries. So we did not feel that it was appropriate or that we were even able to litigate every possible conceivable issue right now when we were focused on the one jury, two jury issue. And that's why we didn't respond to it. But if the court wants us to respond to that, we will. Generally, it's our position that until the defendants, not the prosecution, put their mental state in issue, that tape is not permitted.
Your Honor, it seems that of all the evidence that people have listed in their motion to proffer, that these two subjects, whether or not portions of the defendant's testimony and the December 11th tape come in, are not two jury issues. They're admissibility issues, but they're not two jury issues because the testimony of each defendant was in front of both juries, and most of it, and the December 11th tape also. So these are the two single things that are not the subject of why we're here today.
Well, to the extent that the prosecution has a position to present to the court in regard to whether we have one or two juries, then it is something that is subject to discussion today. If that's all that motivates them or controls their decision, then I'm interested in hearing that. And now that I've asked some questions, now I know what it is that is of concern to them. And in a moment or two, I will be turning to the defense and asking you similar questions.
I understand. It just seems that they've listed numerous things, many of which do fall into the category of random Bruton problems, cross-admissibility problems, and whether or not two brother defendants can receive a fair trial if this were to go to penalty.
Well, like on subjects such as Aranda Bruton issues, one subject one area of that subject that was not addressed by anybody, as far as I can see, is the scenario of a trial conducted wherein the defendants do testify in front of the jury, not by the prosecution reading some prior testimony, but the defendant actually testifying. And whether at that point these out-of-court statements made by the testifying the defendant would then be subject to the so-called Bruton objections that are argued in these briefs. That has not been discussed by counsel at all, and that's certainly a scenario that might arise. I don't know if it will. I don't know how this would play out with the prosecution seeking to offer some evidence that is the testimony of, or portions of the testimony of the defendants, as to how that would affect the decision of the defendants to testify or not later on. I have no way of knowing, assuming that did occur.
Your Honor, before, I know the court is concerned that people didn't outline what portions of the defense testimony they're interested in, but before we can even get to that issue, we have to get to the threshold issue, which the court has to rule on either today or sometime in the future as to whether or not all of their testimony would be admissible in front of a single jury. Now, once we know whether or not it is, then we go to what portions, then we go into the 402 issue and the 52 issues of what portions could or could not come in. But there's got to be a threshold ruling that, I mean, and the people's position is that clearly it is, but I'm sure the defense has another position. That's something that the court has to determine. So in the court saying that people haven't, figured out what portions yet, we haven't gotten to that issue yet because we haven't made threshold, we haven't received the threshold ruling from the court.
Well, I would have hoped that before we get into such litigation, you had given it sufficient thought to decide what it is that you wanted to get out of that sort of testimony that would be the basis for us embarking upon such lengthy litigation. It does require some further research and discussion. I don't think it's a snap judgment here. This is a rather unique situation where each defendant testified before the other defendant's jury over the objection of the other defendant, and now the people seek to offer that evidence in a new trial against both defendants. It's not former testimony in regard to the defendant who was not testifying, but it would only be admissible under some other theory, two of which you have articulated here. And clearly the theory that you articulate under Section 1230 would only relate to portions of a defendant's testimony, not to the entirety of it. And you would have to isolate what it is that you would be referring to in that regard. And if it was under Section 1220 of the Evidence Code, then you perhaps do have this Aranda or Bruton situation arise. Let me turn to the defense here and talk to you about your motion that you filed, or your memoranda you filed in support of your position that there should be two juries in this case. The motions that you filed initially were documents that had been filed by the defense in June of last year in support of your position that there should be two juries. And at that point, the issue was never litigated because not only did the defense want two juries in the first trial, but the prosecution wanted two juries in the first trial. So we never got to the specific issues that you raise in your motion for two juries, or your memorandum in support of the two juries. The people have filed a response, and their response has within it argument relating to the merits of your positions, and also relating to the evidentiary hearing that you propose to conduct in support of your position that there should be two separate juries. The people's objection is, first of all, to your request that this court take judicial notice of proceedings that occurred in San Diego in another case before another court dealing with similar matters that you discuss in your memoranda in support of the two juries. I've read the memorandum that you've filed and your position that and when I say you, I'm talking about the defense, your position that the court can take judicial notice of that transcript and the testimony given at that hearing. The court disagrees with the defense position. The court cannot take judicial notice of testimony given in another court in such a matter. And also, the prosecution objects to the court reviewing and relying upon the declarations that have been filed by the defense in support of its position that there should be two separate juries. Declarations of other lawyers in other cases, and also lawyers in this case, but primarily lawyers in other cases that discuss problems that they have had in representing defendants who are related, and generally two defendants who are brothers in criminal trials where the charge was murder, and most of which dealt with issues of penalty. The people object again that is hearsay, and also on grounds of relevance, which was the basis of the objection in the, also to the, one of the bases of the objection that people had to the San Diego testimony. To the extent that those declarations refer to the experiences of other lawyers in other cases, it is irrelevant to this case. To the extent that these declarations are of the lawyers in this case, either the current lawyers or the previous lawyers, it is relevant. It is potentially subject to a hearsay objection, however, on the part of the prosecution in support of the declarations, but the court is inclined to overrule those objections as far as the declaration of Ms. Abramson and Ms. Lansing. But as to the declarations of all the other individuals, whether they be lawyers in Los Angeles County or elsewhere, they are hearsay and relate to other trials or other defendants and are irrelevant to this proceeding. So the court does sustain the prosecution's objection on grounds of hearsay and relevance as to the San Diego transcripts and the declarations of all lawyers other than Ms. Lansing and Ms. Abramson, and also on grounds of relevance and on the further ground that people have set forth and the court agrees with. The court does not have the authority to take judicial notice of those proceedings in the other court. Of course, the court can't take judicial notice of perhaps rulings of other courts, but not testimony given in other courts. It's not the type of matter that the court is entitled to take judicial notice. That brings us to something else in the declarations and the memoranda filed by the defense, and that has to do with the specifics of this case as to what it is you feel in this case you will suffer or your clients will suffer by way of a single jury trial versus having two separate juries hear this case. And that is what is relevant in the defense motion to have separate trials or separate juries in one trial. And the court would entertain a hearing on that matter only as to the specifics of this case, not what has happened in other cases and experiences of other lawyers. I don't find that is relevant in this proceeding. Perhaps some appellate court and some future matter might feel inclined to take judicial notice of such things, but I don't think that that's the function of this trial court to take judicial notice of what's happened in other cases and other lawyers' experiences. So what is it that the defense wants to offer in this hearing in regard to any detriment you will suffer by having one jury versus two juries?
Your Honor, to respond to the court's last inquiry, we want to offer testimony from the lawyers who are involved in the case, from experts, if need be, and perhaps from witnesses whose attitudes were discussed in our moving papers.
When you say experts, what type of experts are you talking about?
Psychological experts, experts who have had experience in litigation, in cases such as this, who are familiar with this particular case, and who are able to provide support for our position about the prejudice that will that each brother will suffer if there is a joint penalty trial.
Well, again, I'm only interested in what happens in this case, not what might have happened in some other case or what some expert might feel could possibly happen, but the specifics of this case and what witnesses or which witnesses will not testify or will testify differently because there is one trial, one jury versus two juries, or whatever other problems the defense might encounter that would be the subject of a hearing and would be something the court should consider in resolving this issue of one or two juries.
Your Honor, I think that the issue is not just what our subjective feelings are about the prejudice. I think that the court could also entertain testimony from experts who are familiar with how juries consider this evidence, who have conducted jury interviews and are familiar with capital litigation involving brothers, and who can provide the court with some more information based on their experience about the general reaction of the public to this situation, because there have been studies done about attitudes towards brothers and, for example, assumptions that the older brother is, in fact, the leader, is the instigator. And in this case, an assumption like that, which is widely held in the public and which the jurors bring to the courtroom and which the jurors cannot leave behind, is certainly relevant and extremely important for Lyle Menendez. And so I think that experts who have done attitude studies would be able to provide the court with information about beliefs and attitudes that are held in the jury pool.
I'm not inclined to embark on such a hearing. As I said, I'm interested in the specifics of this case, not the views of experts on other cases, but the specifics of this particular case and the specific problems that you will encounter in this case. What you're basically suggesting is that the court conduct a hearing that would resolve the matter in such a way that anytime two brothers are charged with a crime, they must be tried with separate juries. That's basically the defense position if you're offering that sort of evidence.
Well, that may be true, but I think we can narrow down our position to relate it specifically to the facts of this case, because it is more than just juror attitudes that present a problem. It's also the issue of spillover prejudicial effect that evidence that might be presented as to one brother would have on the other brother at penalty. Specifically, we've talked about evidence that would not be admissible and that the jury would not have heard at guilt phase that would become admissible in a joint penalty trial.
Well, again, you'd have to identify specifically what that is, what evidence it is. I don't know if all or the bulk of that evidence relates to the penalty phase or some relates to the guilt phase. But you have to delineate what it is. But again, I'm talking about this case. I'm not talking about, and I don't want to conduct a hearing about the general concept of two brothers being charged with a crime and the defense theory that in all such cases they should have separate juries. That, to me, is not the type of hearing I contemplate. I want to deal with the specifics of this case and what it is that the defense will encounter in this case by way of evidence that you will or will not be able to offer, or any other evidentiary issues or other issues that relate to the specifics of this case. And you can delineate whether they are penalty phase or guilt phase matters. And then we will go forward from there. Once you delineate what it is and provide it to the prosecution, and we can then go forward with a hearing.
Your Honor, if I may, I don't mean to take us off of this topic because obviously we believe that this is a compelling reason why two juries are necessary. But it seems to me that this is the third reason we cited in our brief, and there's two other reasons which are before the court. The evidence is before the court. They were briefed before the first trial in this matter, and those could resolve the problem in and of themselves, and that is the Aranda-Bruton issues and the cross-admissibility issues.
Well, Aranda-Bruton, as I said, might or might not be an issue depending on whether the defendants testify. And if they do testify, that issue might just go away depending upon how the court rules on that scenario.
Obviously, we're allowed to rely on the state of the evidence as it's presented, and that's a decision we would make at trial. I think we have to make a basic decision before we get to the issue. I think we have to assume for purposes of litigating that issue that whether or not the defendants testify or not will be a decision that counsel make at the time the people have rested and we realize the state of the evidence.
Sure.
Also, the cross-admissibility issues are before the court. The court knows what they are. The court's heard the evidence on it. What I'm simply suggesting is this. We can and will present evidence on the third category, which is we don't believe that two brothers, specifically brothers, can receive a fair penalty phase.
No, that's not the hearing that you're going to have in this court. You're going to have a hearing on whether these two brothers,
Correct.
These two defendants, not general concept of two criminally charged brothers.
I misspoke myself. But all I'm suggesting is I think the issue can be resolved perhaps dealing with the first two issues. The court did take a very firm and specific approach and attitude in the first trial, before the first trial, that the court was not going to rule on each and every piece of evidence to give the people the opportunity to make a decision, that the people are going to have to, in essence, roll the dice and take a chance, making somewhat of a knowledgeable decision.
And that wasn't the reason why the court made that decision. The court made that or took that position because the court had no way of knowing how these particular offers of evidence would materialize during the course of the trial, and no way of evaluating it in the context of the trial until they were offered. That's why the court did not embark upon a hearing to provide the prosecution with advisory opinions on everything they hoped to offer during the trial.
Right. I understand that. And
you're now asking the court to make those rulings because you want the court to rule on the cross-admissibility issues first.
I'm not asking the court necessarily to make those rulings. I'm asking the court to put the burden on the people where it belongs to decide whether or not they can make an intelligent decision without the court.
Well, they've indicated they don't need those decisions made other than the decision on the December 11th tape and the decision on the testimony of the defendants.
Well,
that's all they said that they wanted. They said that here. Mr. Kahn said that. Isn't that right, Mr. Kahn?
Those are the key issues, Your Honor. I think that our decision will depend in large part on those. I was also saying, however, that the other issues concerning material which was presented before jury separately is something that we are going to have to rule on at some point. And I would like to rule on those issues before we make a determination as to what it's going to be.
That was my understanding. And so he is asking for more than just those two issues.
No, he said he would hope. He didn't say he needed those. He said he would hope.
Hope springs eternal.
Yeah.
I'm getting very...
Getting back to my point, which I was going to, is simply that if we are required, and if we do get to the issue of these two brothers receiving a fair trial before one jury in a penalty phase, I think that we should present that evidence to the court ex parte and sealed, because it would be involving bringing very sensitive testimony, perhaps from some family members, before this court, which the people are not entitled to know about until such time as we were to get to trial. So
well, that gets back to the question I asked, or at least the subject I brought up. Is most of this evidence, evidence that you feel will be affected by the one jury versus two jury, evidence that would be in the penalty phase and not in the guilt phase? Is that right?
as to that category, yes.
Okay.
So our third reason.
So the issue to be dealt with in such a hearing would only deal with a penalty phase of the trial.
Correct.
Correct.
Okay, and the people have filed a motion to modify the discovery order in which they are asking for access to the defendant's evidence that it intends to offer in the penalty phase. And the defense has indicated you're not ready to respond to the people's motion to modify the discovery order. The people cite the court to a particular case that came down while the first trial was in progress for support of their position. And prior to the first trial, in this case, the prosecution elected not to seek an order of the court to obtain penalty phase evidence from the defense. Now the prosecution wants that evidence. So an issue perhaps to be resolved is whether or not the prosecution is entitled to that evidence prior to such a hearing being conducted, so that if they are entitled to it, then they have it and they can participate in such a hearing.
But the problem, Your Honor, and the whole purpose of that hearing is we have no way of determining what we're going to be able to offer in a penalty trial until we know it's one jury or two juries. That's exactly the problem.
Well, you certainly know.
We're not going to, let me just say one thing. We are not going to tell them so that they can then use it in guilt phase, which they're also seeking a modification of the order to allow them to do, about any potential conflicts that our witnesses may have about the things that they are agonizing about, which we've made reference to. I think that in that sense, to apply 115 to a situation where we have not decided what evidence we can put on in penalty phase because we need to know if it's one jury or two, and to make us expose to the prosecution the very things that these witnesses are concerned about being used, lightens the prosecution's burden and would be unconstitutional to force the defense to comply with that, and particularly when we're dealing with penalty phase evidence in a death case. I think it's precisely, we're trying to make a decision ultimately about what evidence we can put on in a penalty phase, depending on whether it's one jury or two, because that's a decision that involves the consciences of both witnesses and the defendants. And I don't think we should be compelled to give the people the information that's causing that struggle if we are never going to use that information because of the decision ultimately, let's say, to have one jury. So I don't think we can be put in that disadvantaged position in order to try to obtain a ruling on one jury or two juries. It's sort of like the Simmons rule, giving up a right in order to assert another right.
Well, the Supreme Court hasn't made a blanket rule that in all cases the defense is required to turn over to the prosecution penalty phase evidence. It is a discretionary call that the trial court makes based upon representations of counsel. And so that can be part of your offer here. But as I said, the hearing will relate to what is going to happen to the defense if you have one jury. That won't happen to you if you have two juries or vice versa. And that is what I want to focus on. And you say it all relates to penalty phase. So that is then what you'll have to address, other than the other matters that were briefed by the defense dealing with cross-admissibility and the Randa Bruton matters. As I said, cross-admissibility and Randa Bruton type things, both of those issues, to some extent at least, can be addressed or dealt with if the defendants testify. The posture of the court's rulings could very well be different if the defendants testify versus if they don't testify.
I think that may be true with respect to the Randa Bruton issues, but I don't see how it's true to the cross-admissibility issues, particularly those things that refer to misconduct on the part of one defendant or the other.
It depends. Even in the first trial, there was some of that evidence that came out before both juries. If the issue of the defendant's credibility is before the trier of fact, then the prosecution is entitled to attack that credibility. And if some of that attack relates to specific acts of one defendant that relate to his credibility, then that might come in before the jury that's hearing the other defendant's case, and for the purpose of impeaching the defendant's testimony. Some of the people's offers, by the way, and They did use a word processing sort of approach in support of their various offers of evidence, and that after every offer is identified, it's referred to in a generic way as to why it's admissible without too much argument. And many of those dealt with the issue of credibility of the defendant, and the defendant's credibility only comes into play as far as the use of that word credibility if he testifies.
Yeah, but the point was, as the court pointed out, we objected to the cross testimony of the defendants in the last trial. And for example, from Eric Menendez's position, we won't be calling Lyle Menendez in a joint trial before one jury. And if his team calls him, why should my client be subject to impeachment of Lyle Menendez with bad acts that have no reference whatsoever to Eric? He's not calling that witness.
Well, that would happen in any multi-defendant case, would it not? There's no difference between these defendants and anybody else who is charged with a crime and who is tried with another defendant before the same jury. So I'm not ruling on any particular issue here. I'm just saying in general, some of that is resolved if the defendants testify, one or the other testifies, that some of these matters can creep into the trial by way of impeachment of the defendants.
I do note, however,
testimony.
Your Honor, in the last trial, where both defendants testified, the particular matters that have been briefed here were not permitted to creep into the testimony in front of the other defendant's jury.
Well, some of the reasons for that, and I can't identify each and every one now, there were certain objections made by the defense to the use of that sort of evidence before the other defendant's jury on the basis that the other defendant's jury wasn't in court when those witnesses relating to that evidence testified before the one defendant who's testifying, the testifying defendant's jury. Therefore, that jury wouldn't be in a position to evaluate the credibility of the witnesses who supported that those subjects.
That was only
And that
true.
was on some occasions the basis of the objections.
That was,
And also, again, I can't identify each and every one of those. I'm sure that anybody who wants to look at the record carefully enough can identify them for me. However, also the court did have the luxury of two juries in that first trial, and often what happens is with the luxury of two juries, the court errs on the side of over caution. And when you can excuse a jury and have one jury alone hear the evidence, you do that. When you have one jury instead of two juries, you can't do that, and you proceed differently. That doesn't necessarily mean that one ruling was right and the other ruling was wrong. It's just a different ruling under a different set of circumstances.
well, taking that to its logical conclusion, that means then that the defendant's rights are better protected with two juries because the court can be cautious. They're less protected with one jury, and we agree.
Well, that's not what I said. I said that the rulings might be different and the rulings might be correct in both instances. They're just different. And that's the nature of the beast.
Well, the nature of the beasts that we're concerned about are beasts under 1101. And beasts that this court ruled in the previous trial were not admissible, particularly against my client, not because the witnesses didn't testify before both juries, but because the subject matter was considered irrelevant and prejudicial. And it is those issues that are of concern to us even now, not so much the statement issues, although there are some of those statement issues that we feel fall into the 1101 category rather than the Aranda Bruton category. But we seem to be going into a circle. I mean, the problem is part of our motion for separate juries is based on guilt phase evidence such as this, 1101 type of evidence. If what I'm hearing now is that since that is not what is most important to the prosecution, this court is not inclined to rule on those issues, then we have no way of proceeding with our separate jury motion in any rational way if we don't know what the court's rulings on those issues would be.
No, your reason, or one of the reasons for your motion for separate juries is that you feel that if you had one jury, that somehow that would cause prejudice to your client because you could not offer certain evidence that you would offer in a dual jury trial.
That's one portion of the problem. The
And
other
if
problem
that
is
was
the spillover from
well,
bad evidence.
Okay, but if that was decisive, if that last position you have is decisive, then we don't have to litigate any of these other matters that you feel that have to be litigated, all these cross-admissibility issues. If you have a position that you feel is correct, that this should be two juries because the people are charging a capital offense and asking for the death penalty, and therefore the evidence that you would be offering in a penalty phase, if this trial ever got to that phase, requires two juries, then that is the issue that should be decisive.
I sense that we're about to start a new briefing schedule, Your Honor. Shall we?
No, what you're sensing is that that is the first issue the court feels should be resolved, and if it resolves itself in favor of the defense positions, you have two juries, then we don't have to deal with some of these cross-admissibility issues.
Problem is to resolve this with a hearing, Your Honor. Means we have to reschedule, we have to bring in witnesses. It's much more time consuming. I mean, if we have to do it, we will do it, but that's time consuming. That's going to have to be sometime in the future. I'm about to start a month-long trial on Thursday. That's one of the problems.
Let me say this. I think perhaps you can conclude from the posture I'm taking that my feeling is that this case should be tried by one jury instead of two juries, unless there is some compelling reason that there should be two juries, and that compelling reason has to do with the last position of the defense. Therefore, that is what I want to address.
Your Honor, now I understand that you've clarified that apparently you have made some sort of tacit statement on the first two categories.
You can call it a tentative feeling on the court's part.
But that, okay, that tends to, I mean, my suggestion before, I think, still holds. There's three categories or three reasons why we feel two juries are necessary. Two of those categories are before the court. The court has heard evidence on it. They have been briefed and argued previously. Ms. Towry and I, as newcomers to this case, are becoming familiar with those issues. The third issue, the third category, is a whole new issue which was never litigated or talked about the first time, and it does involve a perhaps lengthy evidentiary hearing. My reading of the transcripts and my reading of the rulings from the motions which Ms. Towry prepared for today seem to indicate that previously, as now, the people are asking the court to make numerous pretrial rulings.
And you've stated in your motion that you don't think it's proper for the court to do that the court initially said it wouldn't do that prior to the first trial, and that you think the court should take that position this time.
Correct.
So if the court took that position, then we wouldn't have any of these rulings, and you'd still be in this position.
So if the court takes that position and basically says to the prosecution team now what it said to the prosecution team previous to the first trial, which is, folks, you're not getting a preview of the rulings, make your decision, and then the people make a decision, we may eliminate this whole need for witnesses, a hearing, and evidence.
Okay, I focused on those things that the people felt they needed. I did that before we started the first trial, and as I recall, in June, after the court indicated that it was reconsidering its view that this trial would be conducted with two juries, it's June of last year. The prosecution ultimately indicated that it really wanted the court to resolve, as I recall it, the issue of Aranda Bruton as their big concern prior to a trial commencing with one jury, and that they didn't need all these other issues resolved. They really were mostly concerned about the Aranda Bruton issue. And then the next day they came back and said, no, we've decided we're not going to run the risk of what evidence will or will not be introduced, and we want two juries. And that's how we ultimately proceeded with two juries. And my suggestion is that, number one, the prosecution argues very strenuously that it feels the merit of its position on each and every proffer of evidence, feels its position is correct on all of those items of evidence that they might offer in this case. And again, I use the word might because they haven't decided what they want to offer, and the court really doesn't intend to embark upon a long hearing on things that the prosecution might or might not want to offer. It just doesn't make sense for the court to do that. I don't think any court would do that, to just render advisory opinions on hypothetical situations. If the prosecution feels so strongly that their position is right on all of these positions, then it seems to me that they are in a position to assume that the court will follow the law that they think the law is and rule in their favor on all of those things. And therefore, they would run the risk that some evidence will be received, some evidence won't be received, but that the rulings will be the correct rulings based upon their interpretation of law. But the court doesn't intend to rule on every piece of evidence that they intend to offer or possibly might offer.
And that's the position we were in before the first trial, and if that is the position that the court is taking this time, which we feel is appropriate, which is people, we're not going to rule on everything, you've got to make some decisions based on chances, then let the people reevaluate. Let's come back here and let the people, without all these rulings, say to the court, all right, we have made a decision, Your Honor, we are going to go with one jury, or we're not going to take that chance, we're going to go with two. If they come back and say we're going to go with two because we're not willing to take that chance, then we avoid the necessity of this lengthy hearing, bringing in witnesses and coming up with a whole new evidence that the court has never heard. If the people come back and say, all right, we've made a decision, recognizing we're not getting rulings, we're taking our chances, we're going with one jury, then at that time we can schedule this hearing that we would need, because that also would become relevant at that time. I'm just suggesting, as a matter of saving time and a matter of orderly progression, that the people operate as they had to before, which is make a decision. And I am getting out of Mr. Khan, but he is not just talking about those two issues, the December 11th tape or the testimony of the defendants. He is concerned about some of those issues which lump into the category of cross-admissibility. Let them come back and make a firm decision without court's prior rulings, which is the court's position before and the court's position now, apparently, and we agree. And that then we may alleviate the whole need for this hearing on the issue of whether these two brothers can receive a fair trial.
Well, I didn't say I was not going to make a prior ruling on those two issues, the defendant's testimony or the December 11th tape. I was referring to all these other matters that were the subject of their offer of evidence. I have a little difficulty in dealing with those two items, the December 11th tape and the defendant's testimony, because I don't know exactly how it would be offered and what context and what would be offered. So it's difficult for me to review it and evaluate it. But
interestingly enough, we see those two items as issues that really don't go to the two jury issue, but more go to just simply admissibility issues. The cross-admissibility issues, those things which I call cross-admissibility issues, to me really seem to be the issues as to whether or not the court needs to rule on one jury or two juries.
okay, but you don't want me to rule on those cross-admissibility issues.
That's correct.
So then they won't, if your position is that you don't want them ruled upon, then that is not an obstacle as far as the defense views it to having one jury.
Well,
I'm saying
Your position is you don't want the court to rule on those, so that if the court doesn't rule on them, then that's not something that you would point at as a reason for two juries.
Your Honor, if we can interject at this point, I think what Mr. Weiss is saying, and I think the court picks up on this, is they're arguing three issues in their motion to sever. And the court said, let's not deal with the first two issues, let's deal with the third issue, which is the evidentiary ruling. And I think that that's what the court was focusing in on. Now, Mr. Weiss came back and is talking about, well, he wants rulings on all three of his issues before they're going to make a determination about this, whether they want to go forward with one jury or not.
That's not
But by the same, within that same sentence, he's saying that he doesn't want the people to have any rulings on any of their evidentiary hearings. So either he's saying he wants to discuss all three issues in his severance motion, or he wants to do what the court suggested, just focusing on the evidentiary hearing. And no one's saying what they want to do. And I think that's what the court is trying to focus in on, and I still haven't heard what it is they want to do.
From my previous experience, I think what really matters now is to find out what the court would like to do.
Well, I've already said that, haven't I? I told you what the subject of this hearing should be.
Are we in a position where we want, apart from our hearing, let me just indicate with respect to putting this hearing together so the court understands the realities. The defense in this case has no money, no budget, and Ms. Morrissey is only second counsel until Monday. So if we're going to prepare for such a hearing, there are all these other foundational things that have to be provided for, which we will seek from other courts. But I mean, the fact is, we are not in a position to even fly a witness in here. However, if that's what we have to do first, that's what we'll do. But I'm also hearing the court indicating that it is willing to rule on the issue of the prosecution's admitting the defendant's testimony and the 1211 tape. Do we need further briefing on those issues? I sense that we do. And so how would the court like to proceed? What should we do?
Well, as I said, I don't know precisely how it is that the prosecution intends to offer this evidence as to whether they really do intend to offer it. Perhaps a final decision and a firm decision in that regard would help, specifically in relationship to the defendant's testimony. It's unclear to me exactly how it was to be offered. The defense has presented some response to the people's position. If you feel that you have completely and adequately responded to their offer of the defendant's testimony, then don't have to brief anything else. I'm not inviting any briefs. If you feel that you've completed all the work that you can on that subject, that's fine.
We're waiting to hear what the court indicated it was interested in hearing, which is what part of their testimony and in what method do they propose to offer.
And you also indicate that there is some position you have in regard to the December 11th tape. You indicated that your position is that it can only be offered if the defendants tender their mental condition. And also you use the P word, privilege, in regard to this matter. And is there some position of the defense that you are going to assert a privilege in regard to that tape being played?
If my memory serves, the reason this court ruled that that tape was admissible evidence and no longer protected by the privilege that the Supreme Court felt still protected it was because in that trial, the defendants tendered their mental condition. And therefore, it was a function of the triggering mechanism of their tendering that defense. If they don't tender that defense, under what theory should the people be permitted to play that tape in their case in chief? And the people are proposing a trial in which they basically call the defendants as witnesses by offering their previous testimony. That cannot be considered a tender by the defendant. And I could easily envision if the people go ahead and do that, and if the rules of evidence require that if they're going to offer some of the defendant's testimony, they must offer all of it, I could easily see a situation where we would never call the defendants to testify.
Haven't the defendants waived the privilege by their use of the tape during the first trial and by the nature of the evidence presented in the first trial? Isn't that a waiver of the privilege?
Judge, that could never be considered a free and voluntary waiver. We were told by the court's ruling that the people were going to be permitted to use that tape.
No, I'm talking in the totality, regardless of whether you played it or the prosecution played it, although that could be an issue. The fact that you presented a defense in the first trial, tendered the mental condition of the defendants during the first trial, that constitutes a waiver. Once waived, it's always waived, is it not?
No, I don't agree. Although we can brief this, I don't agree. I mean, there's also case authority that says that when a trial results in a mistrial, the defendants are in the same position they were before that trial began. Now, that may be impossible from a publicity standpoint in this case, but I think legally it should still be true.
All right.
And that may be one of the arguments.
If that's your position, then that should certainly, all these matters then that relate to the December 11th tape and its admissibility, if that is a controlling issue for the prosecution, is it not?
Yes, sir.
Then that should be briefed to its finality as to whether it can be introduced by the prosecution in its case in chief. And also, again, the defense or the prosecution should identify what it is offering of the defendant's testimony and more specifically how you envision that will occur. That does not distract me from my view that there should still be this resolution of the defense position, that there, regardless of rulings on the other objections to one jury, that this issue regarding penalty phase evidence is dispositive, and that that is the hearing that I envision as well, that the defense will have to prepare and present.
Your Honor, may I make a comment?
Yes.
I don't want to put words in Mr. Co-counsel's mouth, but I think what he was trying to present to the court was not a position on the part of the defense that the court should never make any rulings with respect to evidence prior to the trial. I think the court's position last time, and as I understand it, the court's position this time, is that the court is prepared to rule on pieces of evidence that the prosecution feels is crucial to their determination as to whether or not they feel comfortable with proceeding with one jury. And they've identified those two pieces of evidence. And we have no problem with litigating those issues, and I think they should be litigated, although we do need to present much more extensive briefing to the court on those issues. I think what Mr. Weeks was saying is that he believes, and I tend to agree with him, that it might be a better use of both the court's time and counsel's time to piecemeal the litigation so that we can deal with the issue of the prosecution's proffer of these two pieces of evidence in an initial hearing, because that's the less extensive and less expensive hearing, because that's something that can be dealt with in briefs and arguments. The second issue, which is the penalty phase aspect, which we've raised in our brief, requires a much more extensive hearing, and we would be required to bring in a number of witnesses, and we would be seeking to present evidence of perhaps surveys, which would be case specific, or expert testimony, which would be case specific in connection with our presentation to the court, because what our argument in essence requires a prediction in part of what the jury will do at the penalty phase. So that hearing, it seems to me, would be a much more extensive hearing, and it may be unnecessary if the court's resolution of the prosecution's issue and the guilt phase, those two pieces of evidence, is adverse to them. That may be positive in and of itself and make the second hearing unnecessary.
Well, I have no problem bifurcating it so that we deal with those issues first, the ones that are crucial to the prosecution's position. But I don't want to then be in a position of months delays or several months delay to get in the position to deal with this other issue that the defense has. Each side has something they want to have resolved by the court on this subject, and I want to get it resolved as quickly as we can.
Realistically,
Why it can't all be done within one day, or we can together prove each other?
Well, the defense has told us that they have practical problems regarding the amount of evidence that they want to offer in a penalty phase.
It's not only the practical problems. I should indicate something. This case was prepared for 3.5 years before it went to trial the first time. Lawyers became incredibly familiar with the evidence. The court became incredibly familiar with the evidence, and then there was a 6-month trial. Ms. Tari and I have been on this case for 3 months. We are making Herculean efforts to find out what happened for 3.5 years, and it is extremely difficult. At this point, we are not driving the case. The case is driving us. We are having to respond to issues that the people present in front of us, to issues that the court present in front of us, and it's taking us away from that basic task which we desperately need, and that is simply time to lock ourselves in a room and learn what happened for 3.5 years and learn what happened for 6 months in trial. We are seriously impacted in not being able to do that by having to deal with all these issues. If we have to start now preparing, in essence, for penalty phase issues, interviewing witnesses, which are all around the country, bringing people in and preparing that, we are going to have this enormous void of time in terms of basically just learning what this case is all about. I've gone through less than a quarter of the witnesses who testified, and certain people, names are just becoming familiar to me. So if we do get to that hearing, which very well may become necessary, that is fine, but it's going to have to be down the road. It's not something we can do in a month or 2 months. It's going to have to be after we familiarize ourselves with this trial in its entirety. So we're talking numerous months down the road. That's the reason why I'm suggesting that we could even maybe avoid that if we deal with these other categories first. I'm not saying that we should avoid the penalty phase issues. Obviously, we feel those are very compelling reasons. But if we start working on that right now, we're never going to find out what this case is all about. We're just delaying our knowledge. We need a more worldly view of this case before we get to that. December 11th tape, we know what that's all about. We've read about that. We understand that. Whether or not the people are going to offer all or portions of the defendant's testimony, we can deal with it. So I'm suggesting that, one, that is something that is now within our grasp and we can deal with in a month or so. Two, it may resolve the other issue. If it doesn't, then somewhere down the line we will put on the other hearing, but it's not something we can prepare for or start doing in a month from now. It would just be virtually an impossibility. We need to learn the basic facts of this case. We need to familiarize ourselves with testimony of over 100 witnesses and many other witnesses that were interviewed. So we're going to need time on that.
Okay, anybody else from the defense wish to be heard on that? How about the prosecution?
Well, I don't think it's quite dramatic as Mr. Weiss is saying, that if we conduct the evidentiary hearing first, he is never going to find out what this case is about. I simply don't think it's quite that dramatic. If the court wishes to have the evidentiary hearing first, I have no problem with the procedure.
Which hearing first?
The evidentiary hearing concerning the penalty phase witnesses prior to the hearing concerning the admissibility of the case and the testimony of the defendant.
Well, I have no priority as to which should be heard first. It does make sense based upon what the defense has stated to me that we deal with the December 11th tape and the defense testimony first, and then proceed with the defense claims of prejudice if the trial was conducted in a one jury fashion, prejudice in the penalty phase. I had assumed from the nature of the defense briefs that when they argued that that was their concern, that they knew what the penalty phase was all about. If when the defense filed their brief indicating that they would suffer prejudice in the penalty phase because of witnesses testifying differently in a two jury trial versus a one jury trial, I had assumed that the defense, both defendants, knew what the penalty phase evidence was that you're talking about.
That brief was a refiling of a brief that was prepared by Ms. Abramson and Ms. Lansing.
No, there was a separate brief filed on June 20th by both you and the co-defendant.
Right, that's the refiling.
No, there's another one. No, this was
that's just Judge, that's the exact same brief, the one that we,
No,
you're
this
talking about our reply.
Yeah.
Oh, yeah.
There was a reply to the prosecution response. Yeah, in that you talk about the prejudice that would occur in a penalty phase.
You know, one of the
I
things-
assume that you did that because you knew what that prejudice was going to be, so that we wouldn't have to have a long delay for you to show that prejudice to the court.
But one of the things, though, Your Honor, is that we.
I'm talking to
I'm
Mr.
sorry.
Weiss.
In terms of concepts, in terms of the general concept of the prejudice occurring to two brothers, yes, we do understand. We can grasp the nature of that brief. We've read it, we understand it, and we feel it will apply here. In terms of as to who specifically, which family member would testify as to certain things, no, we're not familiar with that. That's the thing we can do. We have not interviewed the family members yet.
I think we offered to make an ex parte showing to the court, which we would be able to do. We're not prepared to do that today, but we certainly would be able to do that. In terms of the other preparation that would be required for the penalty phase hearing, we would ask, or we would be seeking the opportunity to present similar types of expert testimony that was presented at the hearing, the Ayala hearing, which the court found that it was not able to take judicial notice of. But we would want to present testimony from experts regarding the potential impact on jurors when you do have two brothers who are penalty phase defendants, which would be geared specifically towards the issues that are present in this case. that may take some time and some money, as Ms. Abramson indicates. Right now, we will have to seek funds to be able to.
Well, before you seek those funds or before you intend to offer that evidence, you better be in a position to outline what you expect that evidence to be, because it might not be admissible evidence. And I don't want you to go to all the trouble of preparing witnesses and gathering information that might not be admissible in this particular case.
We would just be seeking to present expert testimony that would assist the court in making its determination as to the probable reaction of a jury in this situation. We'd be happy to do that, Your Honor. The point being that
Again, I'm not saying that's admissible evidence, so you have to present me with something that would be an offer in that regard
I understand,
before you
Your Honor.
get to that point.
My suggestion is, and perhaps the court would ultimately rule it inadmissible, but we need to make a presentation to the court.
I understand that. You should certainly make your record, and it might be admissible, it might not. I don't know exactly what it is, but you should put it in writing so that we know what it is before you get out there and start arranging for people to travel here and that sort of thing.
We'll be happy to do that, Your Honor. Again, my point was that it seems that when we do have two discrete areas that are potentially dispositive of the issue, that the area which is the easiest to deal with, which is the evidentiary question as to these two items, perhaps should be dealt with first. And if that's dispositive, then we need not go into the more complex litigation.
No, as I said, I have no problem with doing that first, but I don't want you to get distracted from this other issue, because at some point, I assume if the people maintain their position that they're asking for the death penalty in this case, that you will have to prepare for the penalty phase just in the course of your preparation of your defense. So that if you move up that preparation a little bit, I don't see that as any great hardship.
Your Honor, if I could be heard briefly. I think I don't want the court or counsel to lose sight of the fact that one of the bases for our motion was not just that specific evidence would be lost to us, but what we believe to be a social science reality, which is the tendency of people to group brothers together. And although we have stated that as a general proposition, I think in this case we can prove it, that people tend to consider these two brothers a moon unit, irrespective of their actual differences. We have 12,000 publicity citations to this case. We have a nexus run of the publicity in this case so far. And I have a feeling that by jury selection, there'll be a bunch more, but there are 12,000 references to this case. And I feel that in order to present an adequate evidentiary record on this issue of how these brothers would suffer in a joint penalty trial, we need to do an analysis of that publicity to show how, in the public mind, the two of them have become indistinguishable, irrespective of their individual characteristics, and to do that, to show what we believe to be true, which is the likelihood that a jury would do the same thing. And so that's just another one of those time-consuming, very expensive tasks that I think we have to do before we have this hearing. So I'm just trying to figure out when we could have this hearing, given all the other problems, my trial schedule, Ms. Morrissey's trial schedule. They don't have a trial schedule. They're full-time on this case.
And just one other comment. We've been focusing on one jury versus two juries, although at the outset of this hearing, Ms. Abramson indicated a preference to have a single trial with just her defendant, her client, being tried by one jury, and then the other defendant being tried separately. This court has certainly not indicated and does not indicate that if the people state a position that they want two juries ultimately, that and that's the position of the defendant, Lyle Menendez, that is the way this trial will proceed. There is still that option of two separate trials. And this court has gone through the previous trial with 2 juries. There were many problems that arose during that trial because of the 2 juries. And there are very substantial problems that would occur if we proceed again. And such issues as sequestering juries and things of that nature might very well have to be dealt with in such a proceeding if there was 2 juries. So this court is certainly not resolving the matter as to if all sides want 2 juries, that's how a trial would proceed. So that is something else that the parties should be aware of. There is no right to 2 juries in one trial. If there is a right to 2 trials, those trials could be conducted separately or together, and the court would make that decision.
We understand that, Your Honor. We think whether or not there's 1 or 2 juries, I'm sorry, whether there's 1 trial or 2 separate trials is really Ms. Abramson's issue. It's the court's issue, but it's Ms. Abramson's request not to waive time.
Yeah, well, that is
We
not.
take no position.
Yeah, that is one issue as far as one defendant refusing to waive time, but that is not what I'm talking about. I'm talking about the practicalities of 2 juries and dealing with all the issues that arise with 2 juries, not just the evidentiary issues that you want resolved, but there are a lot of practical problems that arise, and issues such as deliberating juries and juries reaching verdicts, 1 jury reaching a verdict while the other jury is still deliberating, and how to insulate the deliberating jury from what has occurred with the other jury, things of that nature, which because of the nature of the result in the previous trial did not arise, but could very well arise, and could, because of the nature of a trial such as this, the high visibility of a trial such as this, those issues are much different than a trial where there isn't this amount of visibility and there are 2 juries. It's just the issues are magnified enormously and become a greater obstacle to successful completion of a trial with 2 juries. Also, in addition to all these other matters that have to be resolved, and the statutory preference for a unitary trial, and my impression from how the first trial was conducted in this case, that this case can be tried with 1 jury. That's an impression. But there are issues that have to be resolved, and legal issues. The positions have to be addressed. The problems have to be addressed so that it can be determined whether or not this case can be tried with 1 or 2 juries. So I have no problem with bifurcating the hearing in that regard and doing it with a hearing on the people's request to have certain matters resolved, and we can do that. We have the matter calendared for a hearing in this court in July already, July the 22nd.
That involves the subpoena duces tape that was served on Mr. Rand.
Do we have time to get good information to people of the specific parts of the defense testimony that seems to be, or the jury that's time to respond?
Well, let's see if we can do that. When will the people, well, first of all, do the people have anything else that you intend to add to your argument relating to the December 11th tape and its admissibility? Are you going to be offering further briefing or argument, or have you?
Well, perhaps if we indicate at this time that we intend to offer the December 11th tape and counsel is objecting on grounds of privilege, perhaps counsel should submit their motion and we will respond to that motion.
Well, is there anything else that you intend to offer about that tape as far as argument, or you've pretty much said everything you have to say in your brief so far?
Yes.
Okay. And as far as the testimony of the defendants, when will you be able to identify what and how you would intend to produce that? What the testimony would be and how you intend to offer it, how you visualize it being offered.
And I think we should also, focus on the notion of videotape or transcript. Both means are available.
Well, let's just focus on the testimony itself. I don't want to. That's certainly not a issue that deals with decisions on one or two juries as to how the testimony will be offered.
Well, it might, because it might, if the court were to find, for example, that where there is a videotape record of testimony, that the person is intending to use it, but they have to use the videotape, that might influence the testimony.
Influence one?
That might influence the decision of the attorney to use the testimony.
Well, you can brief that if you choose, but that's not how I visualize this. If either side feels, if the prosecution feels that it was critical to their decision, I'll certainly hear their arguments in that regard as far as the mechanics of how the testimony is presented to the jury. But first of all, let's find out what it is of the either defendant's testimony the prosecution wants to offer, and how you envision offering it as far as when in the trial, under what circumstances, things of that nature.
Perhaps we could file our motion 10 days before the 22nd, July the 12th.
Well, when would then the defense have a chance to respond and then the court review it? If you had December the 12th, that.
Speaking on behalf of Lyle Menendez, Your Honor, we would not be ready to litigate that motion on July 22nd.
Why not?
Simply because I think the people have a chore in front of them in identifying which parts of the testimony they want to present. Lyle Menendez's testimony took up 9 volumes of transcript. It took me quite a while to get through it and note it for myself.
Well, I assume they've reviewed it because they have made this offer that they want the testimony presented. So I assume they know exactly what it is they want.
Well, upon receiving their brief, I don't think we're going to be prepared 10 days later on this weighty of an issue.
Well, the legal issues involved, well, there are two things. One is dealing with the specifics of what it is that they're going to ask as far as the entirety of it or just a portion of it. The legal aspects of whether the testimony is admissible at all, those issues remain the same no matter what their decision is as far as how they identify the testimony or what portion of it they want. The admissibility is the same. The issues of hearsay are the same. Right of confrontation, all those things are the same. So you certainly can work on those things between now and then. You don't have to wait for the people's brief in order to do the research on that subject.
I think that if they choose to offer certain portions of the testimony, which portions they choose to offer in contrast to portions they choose to leave out, are going to present a whole host of issues that are going to have to be dealt with. I don't know if we can, certainly we can start thinking about it and getting ready now, but when we see their brief, I'm not so sure we can go through 9 volumes of just Lyle's testimony. We're also going to have to go through Eric's testimony to see what they're presenting there and how it affects Lyle. You're talking about an enormous amount. You're talking about probably 17 volumes of testimony that we're going to have to go through in 10 days and come back with an intelligent response. That would be extremely difficult.
Yeah, I'm going to be trial between now and July 22nd. And right now, I don't have such a time. I can't do this issue. I mean, perhaps I will get Ms. Morrissey back, but I won't know that because Judge Jackson's back next week, and I haven't even, we've been trying to figure out what to do about these issues. So I feel in good conscience in the case before that I was doing some of these issues like that.
What I'm going to do is order that the prosecution file a brief with your position on the defendant's testimony by December the 12th, July the 12th, July the 12th.
We'll take December.
I bet you would.
I want to be in trouble.
All right, July the 12th. And I'll and the defense likewise is to present to the court its brief on issues relating to the December 11th tape by July the 12th. And we'll calendar the matter for hearing on July the 22nd. Any response briefs are to be filed on July the 19th. And if either side needs further time to prepare or respond, then you are to file a memoranda in that regard on July the 19th. If you can't comply with this briefing schedule.
On one brief is due 7/12. I should think we should tell you before then if we can't file it.
All right. Well, if you cannot comply with the order to provide the court with a brief regarding the December 11th tape on July the 12th, then you certainly are to inform the court and opposing counsel of that. Okay, so hearing July the 22nd, with the understanding that if either side cannot go forward, they will file notification to the court and opposing counsel of that fact. In a moment. Just a moment. All right. Anything else that anyone wants to say about the issue of one or two juries or severance, anything along those lines that we should discuss this morning?
Your Honor, I just had a point of clarification on the Ayala issue and judicial notice. And so I tend to agree with the court that the court cannot take judicial notice of the testimony presented in Ayala. We simply supplied that so that the court would understand our need for an evidentiary hearing. However, I do believe that the case law requires judicial notice of the facts and orders in the proceedings in Ayala. That's under evidence code section 452. And I think that the judicial notice is mandatory, providing that sufficient information is given to enable the court to take judicial notice. And I don't hear the prosecution saying that that is the case. So I would like the court's ruling on whether or not the findings and orders in Ayala will be the subject of judicial notice.
What findings and orders?
There was a finding that in a penalty phase, in a case in which two brothers are capitally charged, that a severance of penalty phase was required.
This was a finding by a judge in San Diego County.
Yes, it was.
Assuming I took judicial notice of his ruling in that particular case, what relevance would it have in this case?
I think that they are similar cases, Your Honor. I think that the facts and issues addressed in Ayala are certainly not binding on this court and not authority for this court, certainly, but I think it is helpful to the court, and that's why we ask the court to consider it.
Well, as I indicated, I don't think it is relevant to this court's resolution of the matter to consider things that occurred in other courts, unless it was an appellate court. If an appellate court said that that is the rule in the state of California, that two brothers accused of a criminal act must be tried by separate juries, then obviously the court would abide by such a rule. But because another judge in another jurisdiction made such a finding in a particular case that has no precedential value, no relevance to this court's decision. Otherwise, I would be giving that judge's decision the weight of an appellate decision. And I don't think it's entitled to that.
All right, so my understanding is that the court is rejecting our request for judicial notice based on relevance rather than any other.
Judicial notice of his particular rulings, yes. That's right. All right. Did you want a break? Is that what you're asking for?
Yeah.
Okay, we'll take a recess and we'll resume at 20 minutes after the hour. Don't be late. We want to resume at 20 minutes after. Calendar today have to do with discovery and also the trial date setting, I earlier inquired of defense for Eric Menendez when they expected to be ready, and have directed, and I did direct that counsel for Eric Menendez file a declaration with the court regarding her status.
When would you like that to know?
Well, let me finish off with this discussion. What is the status as far as the defendant, Lyle Menendez, in your state of readiness?
Your Honor, when we were originally appointed on this case, we shortly thereafter we filed with the court a brief indicating that as best we could tell at that time, we were looking at a year from then for trial. We would still like to shoot for that date. At this point, we can't say that we would be prepared before that or after that. So I would like to stick with March target, and as time goes on, we will take the court for that. At this point, there's no reason to vary from that. I would indicate that the startup costs, so to speak, of getting involved in this case were enormous. And although we've been on it 3 months, just getting the files, getting them updated, getting them ready for Ms. Towery to do the legal motions and things that were a tremendous investment, getting space, getting our office to give us the paralegal help we need. We are now hopefully going to be moving at a faster pace, but at this point, I would still say that March of next year would be our target date.
And what is the people's position with regard to readiness?
We're ready whenever the defense is ready.
What is your position regarding setting a trial date?
I would ask that we set it for December 1st, when counsel for Eric Menendez is going to be free.
Well, I'm, first of all, going to require that Ms. Abramson file a declaration so that we know what her status is. My interest, and hopefully the interest of all of us here, is to get this retrial started as soon as possible without any more delay than is absolutely necessary for the preparation by both sides. The problem with creating a target date is that such a date becomes a self-fulfilling prophecy, in that you pick a date and you say that's the date we can be ready, and unfortunately it rarely happens that anyone gets ready earlier than that date if you pick a particular date. I would like to see this case tried earlier than the dates suggested by counsel, but I am mindful of the need to prepare, and am concerned that counsel have sufficient time to prepare. What I will do is require that the defendant, Eric Menendez, or Ms. Abramson, file a memorandum informing me of your status on July the 12th, and why it is that you could not be ready for trial before the date that you indicated of December. And likewise, I'll require that the defendant, Lyle Menendez, his counsel, update the court by July the 22nd of your state of readiness. And we won't select a trial date today, but I do want to get this thing to trial and want to get a trial early, and am reluctant to just delay the case for some date 6 months hence without maintaining hope or expectation that we can try it earlier.
Your Honor, I would indicate, number one, we are desirous, as much as the people and the court, to get this to trial as soon as possible. Lyle Menendez wishes he could have started trial yesterday, and it's only because he has new counsel that need to familiarize themselves with the incredible amount of material in this case that he is being delayed. We are working full-time on this case. We are the county is getting their money's worth out of this. I assure that to the court. This case has taken over our lives, our weekends, our evenings, and everything else. And that will continue. So we are as desirous as anybody is getting the case ready. If we are ready before that, we will be glad to inform the court and start. But once again, it is an incredibly significant case, and we need the time to prepare. As far as filing a document on July 2nd, we just filed.
22nd.
July 22nd, I'm sorry. We just filed under seal, I think about an 8-page document indicating our
Right.
status, and I doubt that in a month from now, things will vary much from that.
Well, you can just update with anything to supplement that memorandum that you filed earlier. You don't have to give me a completely new one, but something that would at least supplement it.
Okay.
And the issue of discovery is one that we briefly discussed on Monday. The prosecution filed a brief requesting that the discovery order relating to what the defense is obligated to provide the prosecution be modified. And the defense has indicated it needs some time to respond to that. My expectation is that we can do that on July the 22nd. And I don't see why it cannot be resolved by then. And when can you file whatever briefs you intend to file on that subject?
Well, Your Honor, I had indicated to the court at the hearing on Monday that my best estimate as to the time it would take counsel for Lyle Menendez to file a response to that proposed modification would be about a month. And that is, as I indicated to the court earlier, that is because it requires a review of not only all of the previous litigation regarding the issuance of the discovery order in the first instance, but I think also we would be remiss if we did not review discovery that was provided and witness statements. Since we aren't new to the case, we don't have that working knowledge at this point. Given the briefing schedule that the court has just provided to us, I don't see how it's possible that we could respond to that as well in that short period of time. The issues that are raised by the December 11 tape and the testimony are certainly significant enough to create a time squeeze for us in terms of filing a brief on the 12/11 tape by the 12th of July and a response by the 19th. So in terms of the modification of the discovery order, I think we'll need additional time, truthfully, because that's a lot of things to handle in a couple of weeks.
Well, I don't understand that you have to look at the witness statements. Why would you have to do that in order to respond to a request to modify the discovery order?
I think that it would be appropriate for us to know what we were litigating, the underlying issues about which we're litigating. For example, if there's a provision in the discovery order that we have no reason to or a proposed change in the discovery order that we have no reason to oppose because we're willing to provide that discovery, it seems to me that we should take a look and see what the discovery is that we're talking about, rather than litigating in the abstract. When the discovery order was issued in this case, all counsel had been preparing the case for almost 4 years and were intimately familiar with all of the underlying facts before discovery was litigated. We don't have that luxury because we are new to the case. We don't have the background knowledge that prior counsel had, both the district attorney's office and defense counsel. And there are many issues that are raised, including the so-called detrimental reliance issue. I think that's how it was referred to in the transcripts, which are fairly complex.
All right, when did you then think you would be ready on that?
Well, I think I'd have to ask Ms. Abramson for her input as well, because of her trial and her circumstances, this requires a joint reply. The discovery order is directed towards both defendants, so I'm not sure when she expects her trial to be completed.
Estimated 4 to 5 weeks.
So probably sometime in, perhaps in early August, first week of August, right?
I'll be able to give you Friday.
How about August 5th?
For filing a briefs or for hearing?
Well, we could probably set the hearing that day and file the briefs, perhaps set, what? Right, it's just a response, so we could file the response perhaps on Monday, the 1st.
Well, the prosecution might have a response too. Let's have your brief filed on the 27th of July. And any response by the prosecution, if there is one, and I'm certainly not inviting any responses, the 3rd of August.
Your Honor, the defense did a motion to modify our discovery to them as well, which we didn't write it in response to, but now that we really needed it, but now that we have the time, we can do that, if the court would like one.
Well, again, I'm not inviting any, but if you feel that your position is not adequately covered by what you've filed, I'll certainly give you the time to do it, since we are setting another hearing date on discovery. You're the one who wrote the brief. If you feel that you want to respond to what the defense says, you can do that.
We didn't write anything, Your Honor, it's just something that was served on us a few days ago.
Well, you wrote something, they responded, and if you feel that you have to respond to it, it's up to you.
Just as the court knows that this is a modification that they served on us, it wasn't a response to anything we did.
Yeah, I understand that.
Okay.
Do you want to file something?
Sure.
All right, then do that on the 27th of July. With any defense response to that on the 3rd of August. Hearing on the 5th of August. So we now have hearing dates on July the 22nd and on August the 5th.
Your Honor, with respect to the discovery issues.
Yeah.
Just one, actually request of the court. I know the court indicated on Monday that its preference to handle all of the discovery issues at one time. And some of the issues have become moot in terms of the prosecution's compliance with the defense requests, because in response to our 3 motions, I think that are pending, we did receive discovery ultimately from the prosecution on we received some of the requested items. However, since the hearing date has been put off until August, one of the things that we have asked in our motion to the court to modify the discovery order pending vis-a-vis the prosecution is that the prosecution be ordered not to disclose new items of evidence or discovery to the media in advance of disclosing those items to the defense. And that has happened on several occasions in the past couple of months. And it's very difficult for us to respond to telephone calls that we receive and inquiries that we receive about evidence that we know nothing about until we read the newspaper. And I would ask that the court, in the interim between this hearing and the hearing on August 5th, order at least that and it can make that order directed towards both parties, that no one disclose evidence to the media prior to disclosing it to the opposing side.
Anyone else wish to be heard on that?
Your Honor, just so we have this clear, counsel is talking about disclosing it to the media. When they filed their papers, what they talked about was a disclosure on a warrant, and we're not going to monitor what we put in warrants, because just because warrants are public documents, so, and that was what their complaint was. There was nothing released to media. It was something that was a declaration of warrant, and we're not gonna do anything about controlling our investigation vis-a-vis what they don't want us to put in our warrants.
We're not saying they can't put it in the warrant, we're just saying they have to disclose it to us before they do that, if they're gonna file it.
We're not,
It's also involved disclosures in the proffer, the people's proffer of evidence.
Of information that we had not received at that point. In other words, they disclosed discovery into a brief that became public before we ever had it. So in essence, the media had access to it before we did. I can't conceive of that being a proper way of dealing with it.
Obviously, if there was evidence that the prosecution had decided it intended to offer that had not previously been disclosed to the defense, it should be disclosed to the defense in a timely fashion, and timely fashion would be defined as prior to it being made public in some document filed with the court, that there is an existing discovery order and one that is easily complied with by furnishing the information to opposing counsel.
Thank you. That's exactly what we're asking, that we get the information before it goes into public.
And in regard, some documents become public because they are filed with the court, such as a search warrant affidavit or a return to a search warrant that apparently is what Ms. Towery is referring to, or was referring to in part. And those things just happen. And that's separate from what you've just referred to, Mr. Weiss. And
Referring more specifically to the people's proffer of evidence, there were, I believe, 3 items that came out in that brief that we had never received discovery on, although the people had it.
yeah, and let me just say that counsel should look at an effort to be more cooperative among yourselves in dealing with issues, whether it's discovery or anything else. When letters are sent to opposing counsel and there is no response, there is concern that somebody is hiding something, or somebody is being deliberately discourteous or contentious for no good reason. And it seems simple to respond when someone makes an inquiry, and to cooperate as much as possible in matters that should never get to litigation, such as issues of compliance with existing discovery orders. As I said earlier, if there is a determination by the court that either side is not complying with the orders of the court will impose sanctions. And the party who is not complying will suffer the consequences. And to avoid that, to avoid litigation on matters that should never have to be litigated, the parties should look at their attitude and their behavior and see if it can conform to a more compatible one that would be more compatible with a ongoing relationship that will exist during a trial. And if it can't, then it's not going to be of help to those who can't conform their behavior to what is normally expected of counsel for either side.
One of the court's concerns, as is ours, is expediting our preparing this case, which we are diligently working on. Part of that preparation is keeping up with ongoing discovery. I believe we have sent 3 letters or maybe more. Ms. Towery has done it to the prosecution requesting items that we know are in their possession. We have not even received the courtesy of a response. It's like we don't exist. If they don't intend to give it to us, we'd appreciate a response telling us why they don't intend to, so we can be prepared to litigate them. If they are going to give it to us and they don't have it at that moment, they could tell us that. But when we get absolutely no response to our numerous requests, it makes it very difficult to remain diligent in the preparation.
Did you want to respond to that, Mr. Khan?
No, I don't think any response is necessary.
I'm sorry?
I don't think any response is necessary.
Well, what Mr. Weiss is saying, that he has sent letters to the prosecution and made inquiries of the prosecution, never got responses.
Your Honor, the defense has been extremely discourteous to our secretary and telephone calls, and I don't think we should start getting into who's more discourteous. prosecution has an obligation to provide discovery, and we will provide discovery in accordance with the law.
Well, the concern I have is that one side or the other, and I don't intend at this point to find fault with one side or the other because I don't know the merits of it, but my concern is that this case is getting off to a rocky start in this retrial because of some animosity that might be generated by miscommunication. And the way around that is to develop some means of communication so that you know what the other side is concerned about and they know what you're concerned about. And when they ask for something and you respond, or vice versa, so that you don't have this needless animosity and antagonism that doesn't accomplish anything other than a lot of heat and a lot of discomfort, but doesn't accomplish anything of any value in the litigation.
That's fine with me. I have never been discourteous to any one of their secretaries, but I can tell you that they have been discourteous to our secretaries and have told them at times that they will not even speak to them.
Okay, regardless of that, assuming that's what happened, get beyond that at this point. You think you could do that?
I can do that.
Okay, let's see if you can. Let's see if the defense can. Let's see if we can do it without any further response from anybody that has to get their 2 cents in to get something else on the record that will no doubt create more controversy than assist in ameliorating the situation. So leave it at this. All sides had better get together and cooperate on those issues that normally lawyers for both sides cooperate about. If you can't do that, then you're all going to suffer, and ultimately it's going to make it more difficult for you to do your job in the way that you think you should best be able to do it.
All I wanted to indicate on the record, Your Honor, is that we are prepared to accept delivery of discovery and motions of facts, which would alleviate a lot of these problems.
All right, that's something that you can discuss with the opposition as to how you go about receiving things. I really don't care, as long as both sides receive what it is you're entitled to receive, rather. And I really don't care as to the mechanics of it, as to how it's accomplished, so long as we don't get into this petty acrimony that really accomplishes nothing. It's been put forward in the way some of these documents from both sides are filed. Sometimes the language used in your pleadings are petty and are designed to antagonize rather than to enlighten. And if you just think about what you're doing before you put it on paper, it might help. So that's just a word to the wise. And if you can't conform to what's expected, and you all know what's expected, you'll just have to pay the consequences. That's very simple. Okay, is there anything else now that anybody wants to discuss on any subject before we recess this matter?
Your Honor, just for clarification on the briefing schedule, the prosecution brief respecting both the 1211 tape and the testimony is due July 12th?
They're not going to do.
Oh, they're not going to be, oh, okay, so that's just the testimony?
Mm-hmm.
Okay, that was my question.
Right, anything else? Okay, we'll be in recess until July the 22nd in this matter, and we'll hear those matters that have been calendared for hearing on that date. All parties are ordered to return at 9 a.m. on July the 22nd.
Thank you, Your Honor.
Just following the court's suggestion, ask the prosecution to give us a copy, and they have refused.
Mr.
Your Honor,
Khan?
if I may address that issue, we gave the court a copy of these documents because the court requested a transcript.
Ordered them.
The court
ordered those.
The court ordered it,
Yeah.
the court ordered for the court because they wanted handy access, I assume, to these different excerpts from the transcripts. The defense has copies of every one of these transcripts. Quite frankly, the people are not the handmaidens of the defense. If they don't want to go and Xerox their own stuff, then they can read their own transcripts. But to request that the people go out there and start making all this extra Xeroxing of stuff that they already have is just simply unfair. And we're doing this because the court ordered it for the court's own ability to be able to get this stuff in a convenient and efficient manner, but I
Right.
feel that that's really our responsibility.
All right, maybe you didn't hear what I said earlier, but I ordered you to provide a copy of that to the defense as well. When you file something with the court, you give a copy to the defense.
So the court is now making a ruling.
I did that earlier. I told you that.
Okay.
Did you misunderstand that too, Mr. Khan?
I
Yes, I
thought
did.
from here now.
Okay, well, that's the order, that if you file something with me, you should also file it with the defense. I indicated that you do not have to supply the extra copies that the court has ordered, the 2 extra copies of those documents to the court, just the documents that you file with me. If you lodge them with me, then you should lodge them with the defense as well, so they know exactly what it is. They could see exactly what it is you provided with me. To me, so that if there's some dispute, if they feel that you left something out or they want to supplement it, they will then have something before them that will allow them to do that.
The court also ordered the defense to do this, and the defense in their response discussed this as being some Herculean effort that they could not comply with, so they never did it. So it was up to the people to basically find every place in the transcript where this had been discussed once before. The people were never provided by the defense with every place in the transcript where this had been decided once before. So I think that what people would ask at this point, is if the court is going to make a ruling that it applied to both sides, and that if the defense basically wants to hold back and wait for the people to do all of this work, then I think that at some point we're going to want to address this. We're basically finding all of these different excerpts of the transcript, xeroxing them and providing it to the defense, even though it is incumbent by that order for them to do it as well. I guess there's a certain fairness there that I'm requesting the court address.
Well, obviously, if you were asking for something to be litigated and that a ruling that was previously made be ruled upon anew, you have looked at the previous rulings and you found them, and you found the areas in the transcript that deal with them. So it's not a Herculean task for you to Xerox those, and when you Xerox them, instead of doing 1 copy, you make 2 copies, and 1 for the court and 1 for the defense. It's a big project for you to do that. And if and when the defense has similar issues that they want to bring to the court for litigation, they'll do the same.
What I'm saying, Your Honor, the defense did, and they referred to it as a Herculean effort, and then didn't proceed to provide anything but the rulings and then the excerpts to their prior motions, and that was what was in the exhibit.
No, I think what they said, if I'm not mistaken, I don't know who used the word Herculean, whichever counsel did, whoever Hercules was or is. You can tell me which of you did that and in reference to what particular issue. But as I understand it, the defense did supply the court with supporting documentation from the record, and also supplied it to the district attorney.
It's prior rulings and excerpts from their motions, not the discussions that the court requested. I'm just pointing out to the court that's what happened, and at some point, if the people perceive there's an unfairness here, we're going to ask the court to address it.
Well, that's fine, but at this point, the court has ordered that this material be turned over to the defense that you provided to the prosecution. And if you have difficulty providing it to the court, then you can always let the court know that as well. But if you provide it to the court, then obviously you can provide it to the defense. It's no big deal. All right. It would seem to me that whichever side prevailed on any particular issue, that's the side that would be most likely to want to show the court the record of the prior proceedings. But regardless of that, whether you prevailed or not, it's of great help to me, and would save a lot of time in relitigating these issues if they do end up being relitigated, if we can refer to the prior record so that everyone doesn't have to say everything all over again, and whatever offers of proof were made, any testimony that was made can be reviewed without doing it all over again in this trial. That's the purpose of referring to the prior record.
Part of the problem, Your Honor, with the ruling that I had, and I wanted to ask the court about this, is that
there were prior rulings that everything was admissible, and that isn't the issue that we're arguing about here, or what I thought anticipated we would be arguing in this motion, which is not whether they were admissible, whether they're admissible in front of one jury. So all the discussion that we pulled, I'm not even sure is even relevant to this argument, because everything we pulled just was the discussion as to admissibility. The court, in every section of that second section that the people cited, ruled all of this evidence admissible. It came in before one jury, and now there's a whole other issue before the court. So we pulled all this stuff from the court, but I'm not sure that this is even something that the court really wanted.
Could very well be.
That's,
Part of, that's a separate issue. But the issue all I'm talking about now is if you pull something and file it with me, you should file it with the defense so that they know what it is, so that there's no complaint later on that you've misled me or you've done this or whatever else that might occur. So it's
now
very.
I have my copies here, which I'm going to give to the defense on the record, so we won't have any problem with it at a later date. Is that okay with the court?
It's fine with me. You do what you want. All right. Those are the documents you lodged with me.
Correct, Your
Okay.
Honor.
We accept service.
For the record, Your Honor.
All right. All right. Anything else then that anybody wants to discuss in regard to this discovery issue or the filing of documents with the court or anything else that might bother you or concern you or trouble you in any major or minor way?
Let's talk about North Korea.
We aim to please, Your Honor.
Okay. Well, let's see if you can do that. All right. We'll be in recess and resume on July the 22nd.